Hello, everyone, and thank you very much for joining us for our webinar. My name is Dustin Saldarriaga, and I'm an immigration attorney at Scott Legal. Today, we're going to spend some time talking about the E-2 visa, which is probably the most popular visa that we handle at our firm. And in fact, our firm was founded on an E-2 visa by Ian Scott, who we have the good fortune of having with us today. We will be saving time at the end of the presentation for questions, so please do feel free to send those in. You can do so by using either the chat function on Zoom or the Q&A function on Zoom. And I am going to go over a few other housekeeping items briefly before we begin. Our firm is a full-service immigration firm. So though we do have a focus on business visas, including green cards, we do also focus on family-based immigration, and we can handle really the full spectrum of immigration issues, whether that is humanitarian, family, business, or litigation. So whatever questions or issues you have, we do hope that you will reach out and schedule a consultation with us to discuss. This webinar is part of a series, and we try to do a couple webinars at least a month on a variety of immigration topics. So do plan to attend future ones if those are helpful to you. After the webinar, we will be sending you an email with a link where you can sign up for those future webinars. Also, we'll be sharing the PowerPoint that you see on your screen, as well as a comprehensive guide to the E-2 visa. In that email, you'll also see a link to our YouTube channel. And our YouTube channel is a great resource because we post our webinars to our YouTube channel, but we also post shorter videos. And again, those cover really the full spectrum of US immigration law. And we try to put really good information and present it in a way that's easy to understand on our YouTube channel. So do check that out. And as I mentioned before, we will be responding to questions, so send those in through the Q&A function or the chat box, and we'll either respond to those live at the moment they're asked if they're relevant to what we're speaking about, or we'll save them for the end of the presentation. But either way, we do plan to get to all questions. And finally, this webinar, as I mentioned before, is being recorded. So please do know that. And again, you'll receive a link to the webinar after the presentation. I will be leading the first part of the presentation, but as I mentioned before, our founder, Ian Scott, will be joining us for the second part of the presentation. And Ian has not only a wealth of experience regarding the full spectrum of immigration issues, he's also personally navigated the process. And that really is a unique trait that really does characterize his perspective and how our firm works with and guides our clients. So without further ado, we will dive into the E-2 visa rules and regulations. The E-2 visa, and in this presentation, we'll be focusing on the E-2 investor visa rather than the E-2 employee visa. The E-2 investor visa is a non-immigrant visa that allows a foreign national who is a citizen of one of many treaty countries to come to the US to develop and direct a business which they have invested in. So it really is a wonderful option for foreign nationals who want to either start a business in the US or develop a business in the US. And that can be a franchise, it can be a startup, or it can be purchasing an existing business. If someone comes to us and says that they want to start or build a business in the US, one of the first things we look at is that person's citizenship to see if they can qualify for an E-2 visa. And if they do, the E-2 really does tend to be one of, if not the best option for foreign nationals who want to grow or build a business in the US. As I mentioned, there are a number of options for an E-2 visa. You can purchase an existing business or start a business in the US or a franchise. And I've also mentioned there must be a treaty between the US and the country of which the foreign national is a citizen. And we call these countries E-2 treaty countries. There are dozens of E-2 treaty countries, and you can find them by going to Google and searching for US Department of State E-2 treaty countries, or even E-2 treaty country list. I believe there are about 80 countries now, and they are around the world: the Middle East, Africa, Latin America, Canada, Asia, Australia, New Zealand. So really, really around the world. Um, and and that is a threshold requirement. You must have a passport from one of these dozens of E2 treaty countries. It's not necessary that you be born in one of these countries, only that you have a passport. The E2 visa is valid for anywhere from 3 months to 5 years, and that depends on what we call reciprocity between the US and the treaty country. Again, to find out how long the visa can be issued for, you can go to the US Department of State website, and you could search reciprocity in your country of nationality. We'll talk a little bit more about considerations depending on whether your country allows, or the US allows, 3 months or 5 years, or anywhere in between for your specific country of nationality. The E2 visa requirements, the main ones you see on your screen, again, threshold requirement: you must have a passport from a treaty country. You must make an investment in the business. The government looks at the investment amount really for 2 reasons. The first is they want to see that you've invested enough of your personal funds to show that you're truly committed to the business, and that if you're granted the visa, you will put a real effort into developing the business and hiring US workers. This is not a visa that's used to come to the US and look for business opportunities. For that, you'd need either ESTA or a B1 visa typically. But the E2 is really when you are committed to the business and it really is ready to begin running. So you need to make an investment in the business. The funds need to be at risk, meaning they need to actually be committed to the business, not simply sitting in a business bank account. You actually need to spend them. We'll talk about some of the common expenditures. As part of the application, you'll need to prove where you got the funds from that you've invested in the business. Typically, any legitimate and lawful source is allowed. So you really do have a range of options. You can have received the funds as a gift. You can have received the funds as a loan. You can have earned the money from work or from the sale of property, like an apartment. Really, the options are very, very broad. However, a few sources of funds that are not allowed are any funds that are retained by the E2 business. So for example, if the business has revenues that it retains, it has not distributed, you would need to first distribute those to the E2 investor before they can be counted toward the investment amount. And also any loan that is secured by the E2 business or its assets will not be considered. But really, it's easier to focus on what's not allowed than what is, because what is truly broad. You have a lot of options there. We'll talk about how much you need to invest in the next slide. It's a very common question, but the things that are typically purchased with the funds, I said before that there are two things that the government's looking for. The first is the amount to see commitment. The second is the government wants to see that you've purchased everything that's needed for the business to be operational once the visa is issued. So typically what we would do is provide a spreadsheet with supporting documents that shows every category of expenditure. And that can be money spent on the office space, money spent on employees, money spent on inventory, office equipment, marketing. Those are the broad categories. And again, it's helpful to think about, if you're starting a business, what are all of the things that need to be bought for that business to become functional? And those are the things that you need to show that you've spent money on before the application is submitted. Now, if you are purchasing a business rather than a startup, rather than starting a business, the investment will look different, because your main investment will be buying the business and its assets, and that's fine too. So typically, what is seen as a sufficient amount, if you're purchasing a business, is the fair market value. So if the business has been advertised to the public and you've paid the amount that it's advertised at, typically that's fine. And usually if you're buying a business, you'd also list either in the purchase agreement or even in the investment schedule that's submitted with the application, all of the assets that you're buying as part of buying the business. So if you're buying a convenience store, it might include the refrigerators, it might include the cash register, it might include, equipment to heat food, things like that, maybe the inventory as well. So you'd list all that out to show, again, that you really have bought all the things that are needed for the business to be operational. The third requirement that you see on the screen is that the business cannot be marginal. What that means, marginal is used in the regulations to say that the business needs to generate enough revenue and profit to support not only the E-2 investor and their immediate family, but also at least 3 full-time US workers within a 5-year period of operating. So this is called the marginality requirement. And again, you do not need to have hired workers before you submit the application. You can use a business plan. We'll talk more about that as well in this presentation. But within 5 years, you do need to have hired at least 3 full-time US workers. The business must be real and operating. I've hinted at this already, but by the time you're at your interview at the consulate, you need to be able to tell the consular officer that all that's needed is for you to receive the visa. Once you receive the visa and travel to the US, this business is ready to begin operating. It's ready to begin hiring. It's ready to begin selling. That you don't need to do other things like get licenses, like find an office space. All that needs to be sorted out before you apply for the visa. So the business needs to be real and operating. The other aspect of the real and operating requirement is that this can't be a passive business. It needs to actually be active. It needs to require US workers to actually operate the business. So how do you show that the business is real and operating? You see a few examples on your screen. In your application, it's good to include a signed commercial lease. It's good, you should show that the business entity has been established as an LLC, as a corporation, or other form, that the business has a website, that the business may have contracts with customers or letters of intent from people who intend to do business with the company, and that you have all the licenses that are needed. Those are just a few examples. Requirement 5, you must be coming to the US solely to develop and direct the E-2 enterprise. So you as an E-2 investor, that is your role on this visa. You can't come to the US on an E-2 visa to work for another company. You can't come to the US on an E-2 visa to look for a business opportunity. You need to be coming here to develop and direct the E-2 business, and you need to actively do that. This is not for a passive business. Bullet 6 on your screen, you must own at least 50% in the E-2 company. This is a threshold E-2 investor requirement. The moment that your ownership drops below 50%, you become ineligible for the visa and for the status. So if that happens while you're in the US, you need to immediately leave. If you have E-2 employees and your ownership drops below 50%, unless you have a co-owner, there is a chance that that your employees who are on E-2 employee visas will need to leave. So that really is a key requirement. If you're in the US on an E-2 investor visa, you need to keep an eye on your ownership amount and keep it at least 50%. Now, because it's 50%, you can have a co-owner who also owns 50%, and they can be either from the same E-2 treaty country or another E-2 treaty country. If they can also, your co-owner can also not be an E-2 investors. So you could have 50% of the company as a national of Canada, for example, and your co-owner could be a US citizen. That's fine, as long as you own at least 50%. And finally, the E-2 visa is a non-immigrant visa, meaning that you need to have the intent to return to your home country at the expiration of your E-2 visa. And that is key. This is not a green card. So at the consulate, when you're being interviewed, and each time you enter the US on an E-2 visa, you will need to convince the government that your intention is not to pursue a green card, but is rather to leave the US at the time your visa or your status expires. So how much investment is enough? Again, we talked about this requirement that you need to have invested in the company, and that money needs to be at risk and actually committed. Again, it can't be in a business bank account. It needs to actually have been spent. The government and the regulations and the law does not give a specific dollar amount. Rather, what the law says is that the investment must be substantial. And that depends on a few things: the type of business, where you're applying and who is actually reviewing the application, and the overall strength of the case. What does that mean? If you are starting a business like a law firm, then a law firm requires very low overhead. You technically could start a law firm with a computer, some licensing fees, some online resources, and you're good to go. That's not a lot of money. So the amount of money that's required to start a law firm at the consulate, the officer will likely be okay seeing a lower investment amount than, for example, if you are starting a company that is engaging in manufacturing, where you need machines and you need a larger space and you actually need people to run the machines. The amount needed for that kind of business will be larger than a business like a law firm, for example. Second, certain consulates see more E-2 visa applications than others, and oftentimes that means that they have an expectation that the investment amount will be higher. So also certain countries tend to see larger companies come to the US and use E-2 visas. So where you apply can impact how much you need to invest. And one of the services we offer, we submit E-2 visa applications at consulates around the world. And so we do have a sense of which consulate would be best depending on your investment amount. You can't really decide your examiner. There is some element of randomness there, but the examiner does have the ultimate discretion on granting or denying the application. So if you do choose an examiner who is in a bad mood or simply wants to enforce a higher standard, even though that could be arbitrary, that is a factor at play. Nothing you can really plan for other than creating the strongest application you can at the start. And that really is what we try to do with our clients. But, it is helpful to know that officers do have discretion. If you are denied, you can reapply at the consulate, and oftentimes the consulate will try to assign a different officer, which is a good thing. The overall strength of the case, well, this is key. Officers don't tend to look at a single factor. And I should say officers by and large do tend to be familiar with the regulations, and they do tend to be fair in spite of, what I said before about there being some element of randomness. By and large, we find that officers do tend to be reasonable. And as part of that, if your investment amount is low, then you may be able to compensate for that through other things. Like, for example, if you are starting a law firm and your investment amount is low, you can show that you have already hired a worker. If you've already hired a worker, and you already have, interest from prospective clients, that goes a long way to show that even though the investment amount is low, this is a business that is likely to generate revenue and employ workers. And at the end of the day, employing US workers really is key to the E-2 business. So if you can show that the business is already doing that, that can compensate for other weaknesses elsewhere in the application. Now, the government has shared something called a proportionality test, which basically says that the more money that's required to start the business, the lower the percentage of that amount the government will require to see. So as an example, if you are starting a law firm, low investment amount, the government will want to see that you've spent all of the money that's required to start that business. In contrast, if you're starting that manufacturing company, and let's say it costs $10 million to start that company, the government is not going to require that you have spent $10 million. Instead, they're going to want to see that you've spent a fraction of that. And it could be half of that. It could be 60% of that. But the point is that as the amount increases, the amount that you need to have spent does go down as a fraction of that amount. If you're buying a business, as I mentioned before, usually the fair market value of the business is sufficient. So, where people do run into trouble is if they're buying a business from a family member or a close friend, where they do get a discount. That can cause a number of issues. One of them being that the government can ask if you're actually spending the amount that is required for the business. The other issue is that the government might question whether the funds are actually being committed and are at risk, or if they're remaining in the family and might actually come back to you. So we do see this come up when people are buying businesses from close friends or family members. But as long as the business is on the open market, usually the amount paid for it is seen as substantial. You will want to make sure that the business you're buying does have a track record of employing U.S. workers. And we'll talk about that more under the marginality requirement. Franchises are a good option for an E-2 visa because they typically have a track record. If you're starting a Subway sandwiches, the government's familiar with that, and they can envision it, and they can see how this is a business that's likely to employ U.S. workers. Franchises also tend to offer a framework for what you'll be spending the money on, step 1, step 2, step 3 in terms of marketing. So it is helpful for the officer to understand a franchise, and they can be great options. We already talked about common good visa, E-2 visa expenditures: marketing, payments to employees, payments for an office space, inventory, equipment. Bad E-2 visa expenditures include travel expenses. If you come to the US to look for a business, if you pay to entertain prospective clients, don't include those. And typically education expenses will not be included unless they are very specific to your business. But we are happy to talk through this with our clients. It's an important part of the visa application process. Do I need to hire employees? The answer is you do need to hire employees. This is the marginality requirement, and it is fundamental to the E-2 visa. At the end of the day, the government wants to see that this is a business that will employ U.S. workers. However, when do you need to hire U.S. workers? You don't need to hire U.S. workers before your application is submitted. You don't need to hire U.S. workers before your visa interview. Really, the time frame is you need to convince the government at the time of your interview that within 5 years of starting operations, your business will employ at least 3 full-time U.S. workers. The earlier you can start hiring them, the better. It is typically not good to show a consular officer that you're going to have no employees for the first 4 years and you're going to hire 3 full-time employees in year 5. That would be a big red flag. But what is better to do is to say, right now, we don't have an employee, but in year 1, we're going to hire someone. And then by year 3, we're going to have a second employee. And then by year 4, we're going to have 3 employees. That's better. But if you're able to hire 3 employees in year 1, that's great. And if you're able to hire them before your interview, even better, but it is not a requirement. And many of our clients do rely on a business plan to convince the government that this is a business that will hire at least 3 full-time workers within 5 years. And we'll talk more about the business plan in the next slide. So what's the difference? How do we define a U.S. worker? So ideally, there is a spectrum. Ideally, you will be hiring W-2 employees. W-2 is the IRS tax form that's given to employees in the United States. And employees, usually there is stability in their work. They're more likely to stay with the employer. They are more likely to receive benefits like health insurance. And so, the government likes to see employees. You can use 1099 independent contractors. Again, 1099 is the name of the tax form. Independent contractors tend to be people who are really in business for themselves. They are not required to show up to work at a certain time. As long as they get the job done, they get paid for it. That's an independent contractor. It's kind of, if you needed work done on your house, you might hire someone to get the job done. If they work 5 hours instead of 6 hours to get the job done. You don't really care as long as the job is done. An employee, you want them there at 9 a.m. You want them out by 5 p.m. That's one of the big differences. You control the work of the employee, and that's what the government likes to see. If you go with independent contractors, usually you'll want to show that you are providing work for more than 3 independent contractors. So if you go the contractor route, you want more of them. You also want to ideally show a longer term relationship. Provide tax forms showing that these are people that you've paid for years. These are not people who show up, do a single task, and then leave. And also, if you're using 1099 contractors, usually you want to show that the industry you're in tends to use independent contractors. If you're in an industry that uses employees and you're using independent contractors, that's usually a flag, and you should be endeavoring to use employees instead. And the general rule is, do try to hire employees. Aim for at least 3 full-time employees within a 5-year spectrum. So how do you prove that you're employing workers or that you will employ workers? If your business already employs workers, you'll provide those tax documents that I mentioned. You'll provide W-2 forms, 1099 forms that prove that you're paying workers. You'll also provide the tax returns for your company that show the amount that you spend on salary and compensation to workers. If you don't have workers, you'll use a business plan. So let's talk more about those considerations. Do you need a business plan? If the business is already employing workers, then it's less important to provide a business plan. So really the purpose of the business plan is to show the government that the business will employ at least 3 workers within 5 years, 3 employees within 5 years. So if your business already does that, then you can provide tax returns and you can provide payroll records that prove that your business already satisfies that requirement. And a business plan is less important in that context. But if your business does not already have workers and you're at your interview, you want to make sure that you've submitted a business plan. A business plan is going to show a few things. There needs to be an executive summary, which really summarizes what the business is going to sell, who you are as the owner, how the business is going to sell its products and services. It's fine. A summary in the executive summary, a summary of its financial projections, and a summary of how many workers it'll employ. The executive summary should be a page or 2. The reason the executive summary is important is because consular officers oftentimes will not spend more than a minute or 2 on the business plan. And if they spend a minute or 2 on the business plan, they're usually just going to read the executive summary. So you want to make sure that that section of the business plan is robust and gives them the information they need if it's the only thing they look at. But you shouldn't assume that it will be the only thing. You also need a market analysis and research explanation to show who your competitors are, who you're going to advertise to, a marketing plan that shows the concrete steps you're going to take to attract clients, who you're going to sell to, a personnel plan that lays out over a 5-year period exactly what roles you're going to fill, what positions you'll fill, how much you'll pay for those positions, and when those positions will be filled. And usually we include a personnel table that shows year by year what roles will be filled and at what salary. And officers tend to really like to see such a table because it clearly lays out the job plan. Also in the personnel plan, describe the job descriptions, provide the job duties that'll be done. You should also include a comprehensive financial plan in the business plan. And again, this is essentially 5-year projections of the profit and loss of the business, including the expenses, revenue projections, profit projections, a balance sheet, so that the consular officer understands where the money's going to come from that you use to hire the workers that you say you will hire. And as part of this, it's really key to make clear in the business plan your assumptions. You're assuming that you'll sell a certain number of products or that you'll have a certain number of clients from year to year and you'll be able to charge them a certain amount. To make those assumptions clear, And in the business plan, I think one thing that's really important for framing the business plan is that it's okay to be conservative in the business plan. Keep in mind that what the consular officer is looking for is that you meet the minimum requirements. So, if you think that your business might be able to employ 20 workers in 5 years, but that there's maybe a 20% chance of that. Much more likely is that you'll employ 5 or 10 workers. Keep it to 5 or 10 workers. It's better to show up for your visa renewal application and being able to say that you surpassed expectations rather than explaining to them why. You said you'd hire 20, but instead you hired 5. You don't want to be in that defensive explanatory position. You want to be in a position where you're able to brag about how well the company's done and how it surpassed expectations. Do you need to hire a professional to prepare the business plan? The answer is you do not need to hire a professional. You can do it on your own, but what's important to understand is that this is not a typical business plan. This is a business plan where a consular officer is the audience. And so you do want to target all of the information to that audience. You want to make sure that all the information you're providing, it's clear why you're providing it and that it is to address one of the visa requirements. So again, this is not your typical business plan that you might pitch to investors or someone else who has a business background. This is to a consular officer who typically does not have a business background, but is familiar with the visa requirements, and you're trying to convince them that they should issue you a visa. So with that, I will pass it off to Ian Scott, the founder of our firm, who has personally navigated this process. So Ian, I'll pass it off to you.
Great. Excellent. Thank you very much, Dustin, for that very informative summary of the E-2 visa requirements. So I'm going to spend some time talking about the E-2 visa developments and some adjudication trends. So what we're seeing at the consulates when we submit consulates or USCIS, when we submit an E-2 visa for adjudication. So the first thing that I want to talk about really just has to do with the investment and investment related to an E-2 visa. So Dustin went over the investment amount and what kind of constitutes an adequate investment. But I think that one thing that you always have to consider when you're making the investment as well is investments that are items that you purchase that are where the purchases are made in the United States are much better than items that you purchase outside of the United States. Now, the regulations are very clear that the ability to purchase things outside of the United States is permitted. That absolutely is permitted. The regulations are clear on that. But what happened is during the last administration, they introduced a concept which was buy American, hire American, and then they introduced a preamble to all of the regulations that said, adjudicate these regulations in the context of buy American, hire American. And so what you started to see is consular officers asking, well, where did you buy that equipment? And making a fuss if the equipment wasn't or the investment wasn't made in the United States. So while we say that some of the investment can be made out of the United States, the overwhelming majority of the investment should be made in the United States to avoid any issues. Now, the next topic is administrative processing. So we don't know the reason why, but what we are seeing is that sometimes, well, first, what is administrative processing? It's when you go to a consulate and the E-2 visa is approved on the merits. So the officer is happy that you've made your investment, that you will ultimately hire employees and that your business is real and operating, et cetera, all of the requirements that Dustin just went over. However, there's some flag in the system that says that they want to do additional administrative processing or additional processing, security check, whatever it is. And often they won't tell you what it is, but they'll say, well, okay, so we think it's fine on the merits, but we're going to put your application in administrative processing. Now, let me give you a great example of this. We have a client who was in the United States on an E-2 visa for 4 years. He was an Australian national, so he was granted the visa for 4 years, has a thriving business with 7, 8 employees. He went to renew his application in Australia, and he is currently still in Australia. He's been there for 2 months because his application was put in administrative processing, and they wanted additional security information. They wanted where did he travel over the last 15 years, et cetera. Now, This has happened, we've seen just a significant uptick in the number of instances where we've seen this. And every instance where we've seen this, the person has eventually been cleared and granted the visa. So it's not like there actually was something there in terms of a security concern. So, just something to be aware of. When I went to renew my own E-2 visa in July, I had no fear that I'd meet the requirements. We had 10 employees and I had no fear that we'd meet the requirements. But in the back of my mind, I was a bit concerned that what if my application goes into administrative processing, and that could delay my ability to return to the United States. And these delays can sometimes be quite significant. In one case, we had a person that was put in administrative processing for a year and a half, and then it was finally cleared, and he was able to return to the United States, or go. Yeah, in this case, it was able to go to the United States because that was the first time filing. Now, the other trend is more USCIS filing. So there are two ways to apply for an E-2 visa. You can apply at a consulate, and that's where most people apply because you get a visa, and the visa allows you to leave and enter the country for the time period of the visa. So if the visa is issued for 5 years, you can come and go for 5 years. But a USCIS filing is where you're in the United States on a particular status, and then you change status to E status. Now, if you leave the country after you have that status, then in order to re-enter, you would have to go to a consulate and have the petition re-adjudicated. So not a visa stamp, but actually start from scratch and have the petition re-adjudicated. So that's why most people generally go to a consulate, because they know they will have to ultimately go there anyway, unless they want to be landlocked in the United States. So they go to a consulate. But we've seen a lot more USCIS filings, and primarily because of COVID and the significant delays at consulates. So if you're in the United States, you can pay USCIS $2,500 to adjudicate the petition in 15 days. So that's definitely that's why we've seen so many more. Before COVID, we maybe had done a handful of USCIS filings, but we've done many over the last few years. So that's a big change. And often, sometimes people will do a USCIS filing, and then also do a simultaneous filing at a consulate, because they realize that they will ultimately have to travel, so they want to get in line at a consulate as well. In terms of the impact of the Biden-Harris administration, there really hasn't been a significant impact. The E-2 visas, I'd say it's one area where there wasn't a significant change in the last administration in terms of overall approval rates. I think that across the board, I think that there was more emphasis on more stringent adjudication of immigration petitions. However, I think it wasn't significant when it came to E-2. I think that there were other petitions that the administration disliked more than they did E-2 visas. So I would say that there's not a very significant impact. In terms of COVID, there's no testing requirement to enter the United States anymore, but there is still a vaccine requirement. I'm not sure. I've heard rumors, I think in May, perhaps that will go away. In many countries around the world, I'm traveling next week, and I had to check 2 countries, actually 3 countries, because there's a stopover in another country. So I had to check 3 countries to see kind of what the the COVID requirements, and none of the countries that I'm visiting have a vaccine requirement anymore. So I think that what we probably will see is the vaccine requirement disappear in the United States as well. And even from a scientific point of view, if someone was vaccinated once and then didn't have any booster, which is acceptable in terms of vaccines right now for entering the US, I think scientists have said that first vaccine is not very effective. That you require a booster to maintain the potency. So, that's TBD. But as of right now, you do need if you obtained an E-2 visa and you weren't able to get some type of exemption, like a medical exemption, there's a requirement that you're vaccinated against COVID to enter the United States. And then I touched on this already, that when I talked about the reasons that we're doing more USCIS filings, it's just that consulates are still very delayed. Some consulates have started to catch up, but some, I think the U.S. consulate in Colombia, I'm not even sure if it's open yet, or if it is open, it just opened. And so some are still suffering the effects of COVID. So I think that that's across the board, even a consulate like Toronto, where in the past you were able to schedule an appointment within 3 weeks of submitting your information. That's still around 3 months, but that's improved from a year and a half, which was the case before. So.
Great. And Ian, we did get a question related
Sure.
to administrative processing.
Mhm.
If someone's application is put in administrative processing, are they able to enter the US in the meantime, say on a B1, B2 visa, if they already have that visa, or say on
Yeah.
ESTA?
Yeah, it's a great question. Probably not. So it's I think that if they did try to enter, they would probably be denied entry. So because when you are when you're put in administrative processing, they don't really say why they're putting you in administrative processing, because they're not kind of give you an indication of the reason, because usually they believe it's a security issue or reason or a flag. And part of my speculation with respect to why so many cases are going into administrative processing has to do with the social media data that they started collecting a few years ago. And not that the reason is because of any individual social media, but I think that because they have all of this data, I don't know what they do with it, but they have all this data that they're perhaps just getting more hits, right? Like, more hits that they have to investigate or whatever, right? Because they have this overwhelming amount of data. So I don't think it's, some people that go into administrative processing, they may not even have any social media accounts, but it's just that the fact that they have all this data might be, oh, wow, this name looks familiar, or something that has prompted more people going into administrative processing. Because as I said before, every one of our clients that has gone into administrative processing has cleared, right? So.
Perfect. Thank you. So we can move on to issues and complex areas for E2 visas.
Sure. So I think that, as I said, there's a significant uptick in the number of petitions where we are filing with USCIS. And one of the biggest differences between filing at a consulate and filing through USCIS is that USCIS will focus on the source and trail of the funds. And when we go through that analysis, it really is, kind of to the level of performing an audit. And that's something that, if a USCIS E2 petition is denied or has there are problems with it, it usually will stem from the source of funds, because it is quite an in-depth analysis. Whereas if you go to a consulate, they for the most part gloss over the source of funds, and that's especially the case depending on which country you're coming from. If the country is not a country that has where the U.S. government feels that the country suffers from a large amount of corruption, et cetera, then they'd even gloss over it even more. We've submit very little information on source of funds, for example, if we're submitting to a U.S. consulate in Toronto or something like that, and the person's obtained their funds from working in Canada or something like that. So. In terms of another thing to consider with E2 visas is gifts are permitted. Loans and gifts are both permitted, but as Dustin had mentioned as well, like a loan that's not permitted is when the loan is secured by the assets of the of the company. And when I say, I probably shouldn't phrase it as it's not permitted, but the amount cannot be counted towards the investment amount. That's probably the better way to describe it. But that sometimes has the exact same impact. It's not permitted, because if you can't count that loan amount to the investment amount, you may not be able to meet the substantial investment amount criteria. So we strongly discourage it. In terms of another, kind of issue that comes up, it has to do with small investment amounts. Like our firm, I'd say we specialize in this in terms of a lot of our cases are investment amounts where the person is investing under 100,000, and in some cases even under 50,000. So those are, in those cases, you really want to make sure that you have other factors that show that your case is a strong one. For example, maybe hiring employees or letters of intent or contracts, or a letter from a CPA saying that you've spent everything that's required for this particular type of business. Another area that you have to be conscious of is if you have an E2 visa where there are two investors. So if there are two investors, so each investor owns 50% of the company, that's permitted under E2. However, what you really would want in that situation is to have a higher investment amount, right? So if we say that, like, maybe in certain consulates, $50,000 might be enough for one investor. If you have two investors, then you probably would want to increase that to maybe $100,000. Because I think if there are two investors, or even an E2 visa with a investor visa with an employee visa, generally speaking, I think that it's the government's expecting to see more investment. The next interesting area is substantive change. A lot of the time, and especially we see this with COVID, is that people, they started one business, they came to the US and they started a restaurant, and then the restaurant failed because, the they was shut down for a year. And then, they say, okay, well, let me start a consulting business instead, or some other type of business that's not related to the restaurant, or that is related. But then that might require an assessment of whether or not the change is actually substantive, because you can't just change, right? You got the visa for activities that you indicated in your business plan, and you can't just change to whatever you feel like, and without doing something. You might have to go to the government and get permission. That's probably the best way to describe it. And then I think Dustin talked about this as well. The family business purchase is another area that is often a problem, and I'll just describe it through an example. We had a client. This is a different client, but it's in Australia as well. We had a client that was approved one year. She brought 50% of a business from her brother-in-law, and her mother loaned her the money for that business purchase. Now, we warned her at the time that this could be a problem, because in essence, the government might think that nothing's happened, right? Your mother's given money to her child, and the child has given the money to, in essence, her brother, right? Brother, sister-in-law, when sister-in-law is related to you, right? So that's immediate relative for the purposes of the US government. So she was fortunate in that it wasn't raised the first time that she went to her interview, and the application was approved. And again, she was from Australia, so they were in the United States. Her and her husband came to the United States, and they were in the United States for 4 years. Then we submitted the renewal application. And she went to Australia during COVID, had to quarantine, and it was quite an exercise. And she went to the consulate, and the officer said, "This application should never have been approved. All that's happened here is money has been circulated amongst family," and he denied it. So what we were worried about the first time, it took them a while to get there, but they denied it. And in essence, the officer was saying that there was no real investment here, right? That nothing really was happening. And whether something was happening or not, who knows? I certainly don't. What really is happening? It looked like something was happening in terms of the documentation that they provided. However, the officer just wasn't convinced and denied. So then they had to start a brand new business, and they had to do this all from Australia, start a brand new business, invest in it, and then reapply, and then that business was approved. So the next slide looks at some of the common reasons for denials of E2 visa, and some of these I'm not going to spend a lot of time, because I think they're evident in terms of if you relate the low investment amount back to what Dustin described. I mean, if the requirement is that you invest a substantial amount and you don't do it, then that can be a reason for denial. Sometimes the nature of the business. So sometimes businesses like real estate businesses, sometimes people want to buy properties and flip them, and the government might see that as a very passive form of business that's not ultimately going to lead to hiring US workers. Sometimes the denial is just a result of the venue, because unfortunately, not all consulates are created equal. And some consulates are very reasonable and predictable, and other consulates are not so much so. And some consulates require high investment amount. We are aware of some consulates where we wouldn't even think of sending a client to that consulate without an investment amount of, say, over 100,000 or something like that. Now, another reason for denial is, let's say someone's starting a business. Like, we had a case where someone was starting an IT consulting business, And they had an IT consulting business in their home country, and they'd had the business for 15 years and had never hired employees, right? So that's very, and that's a very bad reason to be denied, because it's a very difficult reason to overcome. If someone's denied for low investment amount, they can just invest more money and reapply. But in this case, it was one of the rare cases where we actually did not reapply for the visa, because, and we did, warn the client that this could be an issue, and unfortunately it was. Yeah, then kind of related to that, just in terms of another reason, it's just concern that the business isn't going to hire U.S. workers. Sometimes it's the officer as well. We have a consulate that we dealt with regularly in the past, and it was a very reasonable consulate, but it looks like that consulate has a new officer, and recently we've been experiencing difficulties with some of our cases there, and they're both describing the person that and obviously it's a new officer that has come from a different place, and seems to not be familiar with the E-2 visa requirements, and doesn't seem to want to provide an explanation if she has an issue with the petition. And then the final reason is just that they don't, and there have been cases like, clients who come to us consultation after they're denied, and we look at their case and they're just not eligible, right? Like, they either, purchase something and the purchase something for 300,000 and put down 50,000, and 250,000 was seller financed, right? And that's for the reasons we talked about for the loan. Then if you've only invested 50,000, then you're not going to have a substantial investment, so you're ineligible, right? That's just no way around it. You're ineligible. So that's another reason that things E-2 visas are denied. So in terms of renewal, so an E-2 visa, can be issued for up to 5 years, depending on which country you're from. But and let's, for the purposes of this, we'll just say that someone has had an E-2 visa for 5 years, and what did they have to do to renew? So some consulates have simplified renewal procedures, but generally what the consulate is looking for is to show that you've hired U.S. workers, right? So we say that after 5 years, we'd want to see the equivalent of 3 full-time workers, and salary doesn't matter. Like, you can, we have E-2 visas where the person has, minimum wage employees and, 3 full-time employees, and that's equivalent of that, and that's fine. So you can have, 6 part-time employees that work 20 hours a week. That's no problem. And then there's no requirement in the future to expand that. Like, you can continue to renew your E-2 visa with, let's say, the equivalent of 3 full-time people indefinitely. And you'd want to provide financial information, tax returns for a period of time, information related to payroll over a period of time. If some of this, you can provide less and less if the business is doing well. If you have lots of employees and it's profitable, then you can provide less. But the time when a renewal becomes more difficult is when, let's say you have 1 employee and struggling, then we have to maybe submit another business plan as well. And then it may be that that's not even sufficient. So but that's the time that you'd have to probably submit more. And then you want to make sure, the other thing you want to make sure with renewals is just that some of the underlying concepts that make you eligible for the E-2 visa still exist. So for example, you own 50% of the company, and that you're still doing the same business that you were doing before, or if you had changed business, that you had taken the proper steps to notify the government that you were doing this change.
Perfect. Thank you, Ian. So we've had a number of questions roll in, and we have 7 minutes left. So I think a few of these we can answer quite quickly. For a consular interview, does a spouse and 3-month-old baby need to accompany for the interview?
Yeah, so the spouse does, but the 3-month-old baby, as long as you have a babysitter for a 3-month-old baby, the baby can stay at home. If the baby requires an interview and you want to bring the baby to the interview to the consulate, you can also bring the baby to the consulate. If the baby doesn't require a visa, then you should definitely check with the consulate to make sure that the consulate will admit the baby, because they can sometimes be difficult, right? So say the baby doesn't have an appointment, whatever. Like you'll get some people that are very, very like, rule based and not, yeah. So, but you can always, we had that come up once where we, a client asked us that, and we checked with the consulate, and the consulate said, yes, the infant can come to the interview. So,
Right. And in general, anyone under 14, I think
yes. Yep.
usually the interview is waived, the
Yep.
in-person. Um, so if the E-2 visa is denied, are other visas that you might have, like a B1, B2, are they impacted at all?
Not necessarily. One thing that is impacted for sure is if you have ESTA, if you have visa
Mhm.
waiver. So visa waiver is going to be revoked if your visa is denied. Any visa is denied. Now, if you have a B1, B2, there's no reason for the officer to go in and cancel the B1, B2. It is possible, depending on what happens at the interview. Like certainly, if they think if you're put in administrative processing or they think there's a security issue, they might cancel it. But or if they think you misrepresented something, they might cancel it. But generally speaking, there would be no reason for them to cancel an existing visa in your passport.
Mhm. Great. And I know someone asked about the current interview wait time at Toronto. I took a look at what we've been seeing, and it usually is between 2 to 4 months, but that can change at a moment's notice, unfortunately. But those times are better than they were a year ago or so.
Exactly. Yeah.
Um, the employee requirement. Good question. Does it include the owner?
No.
No, it does not.
That's a nice short
Three
answer. No.
U.S. workers
Yes.
does not include the owner or their family
Or their
members.
family. Exactly. Yeah.
Perfect. So let's see. If someone accepted Medicaid, could that? I know there were concerns, especially under the prior administration, about the public charge rule.
Mhm.
If someone accepted Medicaid for health services, do you know how that affects their application, if at all?
Well, I mean, if they were eligible to accept Medicaid, then it's not going to to impact their application. If they were not eligible to accept Medicaid, then I think that could be a problem. I don't even think it's legal, right? So I don't think so. I have no idea, but I don't think it's legal. So that could impact the application if the government were to find out about that. So.
Great. And we have a few questions about how much investment is sufficient for X or Y type of business. For those, I would encourage you to schedule a consultation with us to discuss, because again, it's not only the business type, it's also where you're applying and it's other aspects of the application. Like if you're already employing workers, for example, or if you have letters from people who want to do business with you. But Ian, someone has asked about a legal consulting business. Do you have thoughts for a service
Yes.
type business?
Yeah, so they're definitely viable E2s. I think the issue always has to do with the investment amount. I think that's something that you have wide ranges of what can be considered acceptable. When I started my business and applied for the E2, I'd only spent $15,000, and it was approved. But again, though, we go back to, well, why did they like my application? They liked my application probably because they thought I was a little older than someone just graduating from law school. I went to Harvard Law School. They saw I had a lot of business experience. I had an MBA, and they thought maybe this person is going to be able to make a business that hires U.S. workers. So it was, I had those other. Dustin was talking about some of the other strong things in the application, even though the investment amount was very low. These days, we wouldn't even dream of, well, I mean, we do it if a client wanted to do it, but unless you were doing a USCIS filing, $15,000 at most consulates would not work. But that's a function of the government standard has changed as well. We used to, as a matter of course, file applications in Toronto, for example, with $20,000 investment spent, but now they're much more, much more difficult with investment amounts. So, and the other thing with investment amount is we have other webinars we have other videos that have been made on our YouTube channel that deal more specifically with investment amount that might be a little longer than what we've discussed. So, but I think that, but I do agree with Dustin, the best way to talk through this is through a consultation, because it is very case specific and even venue specific, because if you're going to the US consulate in Paris, we're not going to have discussions about 30, 40, 50, $60,000 because they probably wouldn't accept it. So
Right. Okay, so I know we're low on time. 1 minute left, so we can get through a few of these. I love this question. I'm a newly naturalized citizen in Mexico, born previously Chinese citizen. Can I apply? The answer is yes. All you need is a passport from a treaty country. It does not matter where you were born, and frankly, it doesn't even matter if you've been to the country that you have a passport from, as long as you didn't get the passport through investment. If you did get the passport through citizenship by investment, there is a residency requirement. The investment amount from Mexico really depends on the type of business, as we've said, and holistically the rest of the application. Ian, there's a question here. I'm going to skip the question about the conversion rate because that is going to be dependent on the bank that you use outside of the scope of immigration. For a brand new business, do you go for change of status first, or do you go straight for consular processing on the visa? Ian, do you have thoughts on that?
Yeah, I think it depends on how much of a hurry you're in. So if you're in the United States and you really need to start the business immediately, then you'd want to we have a lot of clients that do a change of status and then do a simultaneous filing at the consulate. If you have time to wait, the consulate's always better, almost always. If you're from a country where you have a long visa issuance period, it's better. The only time it's not better, it's where in those cases it's the same. There's certain countries where the visa can only be issued for 3 months, so that generally puts you in the same position as a change of status. So but generally speaking, that's very few countries that's the case. Bangladesh, I think Egypt, there are just very few countries that are like that. So most have much longer validity period. So if you have a longer validity period, the visa is always better because you can leave and re-enter, but it's just a matter of whether you have time to wait to get the visa.
Perfect. Thank you, Ian. And thank you all for participating. The recording will be made available as well as the slides. We'll send you an email afterward that will tell you how to find those. Ian, thanks so much for sharing your expertise with us, and to our audience. Thank you for the great questions and taking the time. We hope to see you on future webinars.
Great. Thank you, Dustin, and everyone for joining. Thank you. Bye-bye.